Welcome, everyone. I'm so pleased you were able to join us today. Before we get started with the program, I'd like to go over some housekeeping with you. At the end of the presentations, we'll have question and answer period. Please use the Q&A instead of the chat feature, and that way we can catch your questions. You can also review the questions and vote on the ones that you like, and those will rise to the top. Also, we will be reporting your CLE to the bar at the end of the program pursuant to Supreme Court rules. We only send in the names of the people who stay for the requisite 60 minutes. If for some reason you bounce off and you have to sign on using a different identification, please email me at lori.nelson, LORI.NELSON @law.utah.edu so I can make sure to get your name and we can track it on the program. With that, I would like to turn the program over to Dean Elizabeth Kronk-Warner, Dean of the University of Utah S.J. Quinney College of Law. Thank you, Dean, for inspiring this program, and I will turn it over to you.
Hey, thank you, Lori, so much. And hello, everyone. I hope you're all having a great end to your week. It's really lovely to be able to spend this time with you. As Lori mentioned, this is a topic that's personally near and dear to my heart, as Indian law is my area of practice. And I could not be more honored to share today's webinar with two gentlemen that I truly respect. But first, I'd always like to start off by acknowledging that my pronouns are she and hers, and also acknowledging that the land that the University of Utah's land is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And I'm very excited to host today's conversation. It's an appropriate and timely conversation given Monday is Indigenous Peoples Day. So it seems appropriate that we should be talking about Indian law. And as mentioned before, we have two exceptionally distinguished speakers here with us today who are going to each speak for about 10 to 15 minutes. And then as Lori mentioned, we'll have question and answer afterwards. I'll be moderating the question and answer. So if you have any questions, feel free to put it into the Q&A button at the bottom of your screen at any time, and then we'll leave plenty of time for that Q&A at the end. So with that, I want to briefly introduce our incredibly distinguished panel, and then we'll turn it over to them to start the discussion. So first we have Darren Parry, who is former chairman of the Shoshone Nation, does business development for the Northwestern Band of the Shoshone Nation, and he also serves on several boards, including the Huntsman Cancer, PBS Utah, and Utah Humanities boards, in addition to having authored a wonderful book on the history of Indian relations here in Utah. Next, we have Dustin Johnson, who I'm very pleased to say is an alum of the S.J. Quinney College of Law. He also currently serves as the Utah Division Director of Indian Affairs for the state of Utah and is an assistant professor at Utah Valley University teaching Indian Studies and Political Science. So with that, I will turn it over to them and look forward to our question and answer at a later time. Thanks so much.
Well, thank you for having us. And I think I'll go first, if you don't mind. I'm probably the only non-attorney on the call, so be kind. To say that my relationship as a Native American leader with the federal and state governments is complicated can be probably classified as a major understatement. I am, among other things, a citizen of the state of Utah, a citizen of the United States of America, and a citizen of the Northwestern Band of the Shoshone Nation. We are a sovereign nation within a state, within a nation. What could go wrong? Starting in 1492, Native Americans were considered strangers in their own country, relegated even lower than second-class citizens. because at least second-class citizens had citizenship. Native Americans, in most cases, were not given the right to vote, even as late as the 20th century. While Utah was a little better than some of their neighboring states, reservations were not giving that right to vote here in the state until 1957. American Indian law, for me, has many ironies, I guess you could say. Tribes look to the US government for recognition as nations, but it's the same government that took many lands and possessions, mostly by force or removal, and sometimes by treaty. The assault has never stopped. Descendants of all Native Americans must apply to become citizens of their respective tribes, with all kinds of paperwork involved. This is a cumbersome activity and different for every tribe. Yet, they are born citizens of the United States of America by virtue of being born. And most ironic to me is that we have an entire body of law that exists about American Indians that they had no part in shaping. And in many cases, they still don't. According to some Indian scholars, the explanation for these incongruities is that in the eyes of the US government, the American Indian is not a racial classification. It's a way of defining the government's political relationship with the Indians, the balance of which has never been tipped in our favor. The key to understanding this relationship is really being able to understand tribal sovereignty. The definition describes it as supreme and independent political authority. That sovereignty granted to my people and what we experience daily is far less than that. In the Rights of the Indians and Tribes, published by the American Civil Liberties Union, sovereignty gives tribes the right to form tribal governments, determine for themselves tribal membership, regulate tribal and Indian property, assess taxes, establish law enforcement systems, regulate domestic relationships, regulate commerce and trade, and exclude members from tribal territories. Yet, at the same time, Congress has the power to revoke tribes' recognition and declare it non-existent, or place it under the jurisdiction of the federal government. The Supreme Court has ruled that Congress has the power to regulate commerce with Indian tribes. The Indian Commerce Clause is the main source of federal power over Indian tribes and has been the primary vehicle used by Congress to recognize and define tribal sovereignty. In addition, the court has ruled that Congress, as a legislative body of the nation, has an intrinsic power to deal with Indian nations that reside within the borders of the United States. Presidential powers, or what once were presidential powers over Indians, were centered in the president's ability to enter into treaties that were often used in those early years to secure tribal acquiescences to the demands of the encroaching settlers. In 1871, Congress passed legislation that ended the practice of the United States entering into any kind of a treaty with an Indian tribe. In the 1950s and 60s, Congress dissolved more than 100 tribes, stripping them of their status and, more importantly, funding necessary to establish governments, claim land, and provide social services. The termination of many tribes left many with no home and no sense of identity. Termination as a whole fulfilled white needs, and termination of the Southern Paiutes in particular fulfilled Senator Arthur Watkins' needs. Watkins, a Utah senator, held a worldview colored by paternalism and a driving religiosity that overshadowed more moderate options. Senator Watkins' assimilation was the only way to deal with the Indian problem. Reservations would be eliminated under his plan. Special assistant programs would end. And land, Indian land, could now be taxed. And that was his solution to making the Indian problem go away. Today, because status as a member of a federally recognized tribe provides us with money and psychological benefits, members now have been quantified and we've become officialized. We now have to carry a card. For membership in some tribes, you must show proof that one or more of your parents is full-blooded members of that tribe, while other tribes require documents that prove a relative is a member. Some tribes even require that children born to enrolled parents on the reservation must petition for membership, as they too may be too many generations removed to qualify for membership. Enrollment requirements that are document-driven tend to dehumanize the concept and identity and diffuse any sense of home. Blood quantum was never a Native American concept. The politics of tribal enrollment have created a certain amount of enmity among its people. Indians are now looking at those with closer blood ties as being more pure Indians. But to me, this is foolish for Native Americans to criticize one another for a policy that was never initiated by Indians themselves. Our experience, especially with the Northwestern Band, as a tribal nation began to change in 1847 with the introduction of the Mormon pioneers. We were indigenous to northern Utah and southern Idaho, and the influx of thousands of pioneers put a great amount of stress on Sagwitch, our chief. It seemed that there was not enough resources to go around. All of those pressures eventually led to what we now recognize as one of the largest massacres of Native Americans in the Western United States. This is the Bear River Massacre. On January 29th in 1863, Colonel Patrick Connor and his command of California Volunteers attacked a sleeping Indian village in the early morning hours of the day. The soldiers shot, raped, bludgeoned, and bayoneted several hundred men and women to their death. 10 years later, in 1873, the survivors joined the Mormon Church. Some of my academic friends say out of the sheer need to survive, and some say because they had spiritual manifestations that they'd been receiving. Regardless of the reason, we began at that time to assimilate into the Mormon culture. In the 1880s, as most tribal nations were now being reassigned to their homes on reservations, we were told by the Department of Indian Affairs that our new home would be either Fort Hall with the Bannock Shoshone or Fort Washakie with the Eastern Band. If we would have had to have chosen, we would have clearly gone with the Eastern Band under Chief Washakie. They were our relatives. They were our people. The Shoshone Bannock were from the Boyce area and not any relation at all. Brigham Young, however, took that decision away by declaring that we are Mormons now and that they are going to teach us their ways. A farming community was established in northern Utah, which we called Washakie Farms, named after the great Eastern Shoshone chief. We were given no reservation land, and it's still that way today. From that point on, our experience with other tribal governments, state governments, and federal governments has been different than if we would have been on a reservation. The primary difference is we do not have a reservation and therefore we do not have civil and regulatory local governments. That being said, we're still a sovereign government recognized under the U.S. Constitution with formal jurisdictional government-to-government relationships with the federal governments and with the state. This means that our relationship as a tribal government flows through the federal government and then to the state. We do, however, have a bilateral government-to-government relationship with the states in where we reside. Because we do not live on a reservation, Northwestern Band tribal members are under the jurisdiction of state and local governments for external affairs such as education, welfare, law enforcement, and the court systems. The only exception to this would be to the lands that the tribe holds in trust by the U.S. government, where federal law applies. It's 184 acres at the old town site of Washakie. The tribe has under authority, under treaty and federal law regulations to take lands into trust with the designation of the Treaty of Box Elder in 1863 and the Fort Bridger Treaty of 1868. 3 years ago, we exercised our treaty rights to hunt and fish under those treaties within the boundaries of the land designated in the Fort Bridger Treaty. We went to the state of Utah and told them of what we're going to do. We established laws and a booklet and came up with hunting dates, and we started doing our own thing. Much to our surprise, we got no pushback from the state of Utah. Our ability to take care of the land, take care of the environment, and make sure that we're doing the right thing by the game and fish is who we are as a people. And so we shared our harvest numbers with the state, and that experience has worked out well. The state of Idaho hasn't wanted to recognize our sovereignty and has pushed back at every turn. And just months ago, we filed a lawsuit in federal court against the Idaho governor and the state of Idaho for not allowing us to exercise our treaty rights within those boundaries that were set by the federal government. Since that time, and I had a meeting this morning with the 3 representatives from the Attorney General's office and the Fish and Game here in Utah. Utah wants to come back to the table and maybe put another agreement together, one where they would have more input. The only problem with that I see, and look, I'm all for compromise and not going to court and doing everything we can to work together. That's what I've built my whole life on. But as I look back on that, as we compromise any of our treaty rights, we're really compromising ourselves. And so while I am anxious to work with and happy to work with the state of Utah, it's going to come at a cost at our sovereignty. And I appreciate the opportunity to share a few of my thoughts today. And I'll turn this time over now to the Director of Indian Affairs, Dustin. And I told Dustin before the meeting, my father served as in that job for a lot of years previous to Dustin. So I'm grateful for his service, Dustin, and I'm grateful for what you do for the people of the Native people in Utah.
Thank you, Darren. I really appreciate that. And I really do appreciate all those who serve their people, serve their communities, and do their best to make those decisions. I know they're hard decisions. And what I've learned really quick working in government is that you cannot satisfy everyone. And it gets pretty difficult sometimes. But I appreciate this time given to share a few words and to a little bit of information that may help you as attorneys here in Utah, and the high possibility of you working with tribal governments or taking on tribal clients. I guess first, my name is Dustin Johnson. I'm Navajo. I was born in Gallup, New Mexico. I was raised about a half hour north of Gallup. Gallup borders the Navajo reservation, and it's surrounded by reservations, Apache and Zuni and different Pueblos. And I was privileged to grow up there. I was raised on the Navajo Nation. I left there when I graduated high school. I came up to BYU to go to school, and quickly realized how much I missed home in doing that, but also realized how much I really like people, and I like working with people, and I like sharing things to help things work better. If there's any Navajos on the line, going at Nishlingi Kintlachini and Shlan Bilagana Bashish China, Honagani Dasha Chedo, Bilagana Dasha Kutali and Nishlan. As a Navajo people, we really believe we're all related, and to prove that, our system of government recognizes clans. The clans you're born in, and at the end there we say Akut Alden and Michelin. After you introduce your clans, you say that, and literally that means this is what makes me Navajo, a Navajo man, are the clans that make you you. And I have had the privilege of working in Indian law since 2006, and up until now, I guess all those years minus about 3 of them, I worked as a tribal court judge. I worked for a Navajo Nation for their legislative council, and for the Navajo Nation Department of Justice and their water rights unit, and I really appreciate my time there. My wife is from Camas, Utah, which is up in the mountain. She is Sioux Assiniboine and Navajo, and coming back to Utah after we increased our family size with children was something that we really wanted to do, and because we really do enjoy it here in Utah. It's a good environment. As director for the Division of Indian Affairs here in Utah, I worked with the governor's office, and when I was hired and appointed, I was told, really frankly, we need to improve the relationship between the state and the tribes of Utah. The words were said that, mistakes were made, things were said, and we need to fix that. Can you fix that? And I said I would love to try, and because my kids are Native, my wife's Native, we have a Native family here, and if I'm going to raise my family here, I need the state to be a safe place for them, a good place for them. And one way to do that is to better those relationships between the state and the tribes of Utah. In Utah, there are 8 federally recognized tribes. That's a surprise to some people. As Darren has said, they're federally recognized tribes. I mean, they have governments, they have laws, they rule themselves by them. They can determine quite a few things as they relate to their own tribe, and they exercise a governance over land and area. Then one of the first tribes I'd like to introduce is the Navajo Nation. They're located in southeastern Utah, mostly in San Juan County, as far as the reservation is concerned. As far as Navajo people, along with all other tribes, as individual Indians, work throughout the entire state. Okay, you're going to run into us somewhere. And another tribe down south is the San Juan Southern Paiute. They actually are without land also. And the Navajo Nation, after they made their initial treaties, kept expanding their borders, and it kind of just swallowed up the San Juan Southern Paiutes, and they were left without land, though they were still recognized as a government. The Paiute Indian tribes of Utah are located, their headquarters are in Cedar City, Utah, but they're up by as far north as Cove Fort and down to the southern border are their traditional lands that they've maintained. And Mr. Parry has spoken about termination. They were terminated in the early 60s or mid 60s by the federal government, meaning they were not Indian anymore. Racially, they were still Indian, right? But as carrying a legal status of being Indian and having a government that was recognized by the federal government as sovereign, that wasn't happening at that point. And through a lot of hard work, through a number of different people, Mr. Parry's father included, but with Larry Echohawk, Mary Ellen Sloan, and this surprises people, Orrin Hatch came in. He defeated Senator Moss, and Senator Moss was ready to support bringing back or ending the termination of the Paiute Indian tribes. And when Orrin Hatch won his seat, they approached him and said, "Hey, this is what was happening. Will you support?" And without question, he jumped in and helped make that a reality. And the Paiute Indian tribes are in Cedar City. The Ute tribe are located in the Uinta Basin, Uinta Ore Basin out in Fort Duchesne, just south of Vernal, and Roosevelt, Duchesne County, Uinta County. That's the second largest reservation in the United States. Navajo Nation being the largest reservation in the United States, but just a portion of it comes into Utah. The rest is in New Mexico and Arizona. The Northwestern Band of Shoshone, currently headquartered in Ogden, and you got that background from Mr. Parry. We have the Confederate Tribes of the Goshen Reservation that are located 1 hour south of Wendover, Nevada. There is something south of Wendover, Nevada. So if you're ever wondering where that road goes to, it goes all the way down to Ely, Nevada, or down to Ibapaw, Utah, where the Confederate Tribes of Goshutes are. The Skull Valley Band of Goshutes, they are located just south of Tooele, and they're headquartered in Tooele, and they have a number of health clinics that they operate there. And last but not least, the Ute Mountain Ute Tribe. They are headquartered in Toyac, Colorado, but they have a community just outside Blanding, Utah, called the White Mesa Community. And so these 8 sovereigns, they operate here, and they carry on relationships with the federal government and the state government. And as with most governments, there's always a little bit of conflict. And I won't say hate, but it's conflict, right? There you have governments that each want to do the best thing for their constituency, for their people. And those things aren't always going to align. When I was hired for this position, I was interviewed by the 8 tribes, and they said, "Hey, you're a state employee. How are you going to make all this work? How are you going to make everything, flowers and and cupcakes, And I said, that's going to be hard, because not only do you have 8 tribes that may not all get along or may not always agree on things, we're throwing in a state government on top of that to see what we can work out, and it can be difficult. When I was working with Navajo Nation, it was during the Little Colorado River Hopi Navajo water settlement dispute that was going on. We had protesters outside of our offices all the time, and when we'd leave the office, people would be yelling at us and telling us how we should move forward and things. And I remember being yelled at and being told, "Hey, don't settle for anything less than 100%. And I was just like, anyway, I want to go home. I got my car, right? And I started driving home. And then I started to realize that if you get 100%, you're not really settling. You're getting everything you want. That's not a settlement, right? A settlement is basically getting together, finding all those things that you agree upon, and putting that down in writing. And not dismissing the things that you don't agree upon, but coming to an understanding that we're going to continue working on these things and hopefully solve those as time moves on. This is a difficult thing, working with tribal government and working with state government and federal governments, trying to get everyone to balance their needs. But I say this, and I say this with the utmost respect, that I believe truly that tribal governments are sovereign governments, that they are just as sovereign as the United States, that they are just as sovereign as any state within the United States. And if you disagree with me, that's fine, but we will have words. I'm just kidding. No, that's where I stand. And the more I study Indian law and the more I work with tribal governments, the more strong that belief is to me. The United States gets its sovereignty and its powers. They're enumerated in the United States Constitution. They're saying the legislative branch does this, the executive branch does this, the judicial branch does this. And then later on, it says any powers not set aside for the federal government are reserved to the states and their people. But where do tribes get their authority? Where does tribal sovereignty stem from? And the reality is that tribal sovereignty predates the United States Constitution. We know this because when people were landing on these shores, they made treaties with the native nations here. Treaties are acts of sovereign nations. The parties in a treaty are not a government and a race of people. Treaties are between two governments, two political entities. And the European nations that landed here recognize that. They recognize the value in that. And they put that down on paper, recognizing tribal authority. And as time went on, and after the American Revolution, when the United States government comes into place, they inherited those agreements. They inherited that relationship that was set up with the Spanish, the French, and the English. And so we know that to be true. And and because of that, we're going to have this conflict. And we find ourselves in a precarious situation, right? Where native nations are nations within a nation. If you're the Hopi people, you're a nation within a nation within a nation, because their reservation's right in the middle of the Navajo Nation. But it's still the truth. Indian country outlined in reservations, those borders are still valid, right? If Congress has not reduced those borders or changed those borders, then those borders are still valid. And they can make huge differences in court cases. One that I'd like to just reference you to is McGirt, MCGIRT v. Oklahoma. The Supreme Court basically ruled that a third of Oklahoma is still Indian country, which scared Oklahoma to death, right? It's because they were exercising jurisdiction over Indian people in Indian country until this case comes out. Okay. Related to this case, but not a lot of people think about it, is a case covering the Indian Child Welfare Act, Brackeen v. Holland in Texas, right? They're trying to overturn the powers and mandates within the Indian Child Welfare Act. And the state that has one of the most Indians within it, Oklahoma, being threatened by McGirt, jumps on that and says, yeah, you're right. The tribes don't have jurisdiction here. The tribes shouldn't even have input here. It's hurting the native children that are involved here. Brackeen v. Holland, take a look at that. It's going to the Supreme Court. It's just out of the Sixth Circuit. US v. Cooley. US v. Cooley, before, tribal law enforcement was very limited on what they could do to non-Indian or non-members within the reservation. US v. Cooley really expanded those powers on what could happen, on what can be affected by tribal law enforcement. And all these things, all these cases that I'm sharing with you are things that my office has to stay on top of. We have to contact the state attorney general's office. We have to get a hold of emergency management and public safety and say, hey, you might need to get out on this and start speaking to tribes. Because the reality is governments can only get along if they're speaking with one another. And so we encourage that. The state of Utah has been very good at designating tribal liaisons in each executive agency to make sure that that these agencies are contacting tribal governments anytime tribal governance may be affected and over its people or over its lands. And so it's really important. One last thing I wanted to share with you is something that Mr. Parry brought up, and this idea about blood quantum, right? Using blood as to make a determination if someone's Indian or not. You know, defining Indian can be difficult, and all the legislation that you'll see that affect Indian people has different definitions about who is Indian. Sometimes you just have to live on a reservation. Sometimes you just have to live near a reservation. Sometimes you just have to have descendancy. Sometimes you have to be recognized by your actual tribe has to recognize you as a citizen member. Okay. But there is a difference between racial and legal status when it comes to defining Indian. I'm racially Indian, right? But legally, I'm a citizen of the Navajo Nation. And because of that, I enjoy certain rights and privileges associated with that legal status. Could be hiring preference, could be hunting rights, it could be a number of benefits received from federal government. Yeah. But that's no different than any rights and privileges the average US citizen receives from the United States, right? There is no race, you know, there's no, I'm American race. You know, we don't say that. We're American citizens that come with rights and privileges associated with it. And I think if you walk away with anything from here, I hope you walk away from that with that there are rights and privileges to citizenship, no matter what government you're a citizen of. And I'll stop now because I think we can cover the rest with any questions that you have. Thank you.
Wonderful. Che Miigwech, we really appreciated, thank you very much. We really appreciated those comments. So again, now we've got roughly 20 minutes or so for questions, and I see that several questions have already been submitted. So our first question says, this is interesting, really interesting. Darren gave us an eye-opening view of Native American rights, or what is probably more correctly stated, the lack of rights and the very peculiar way Native Americans are treated. My question for Darren is, what are the 3 most important things you would like to see change, which would improve Native American status in Utah?
I think that's a wonderful question, and I wish I had the power to do it all, but I think one of the biggest things would be for the state of Utah to really, truly recognize our sovereignty. And by that, look, we have a great relationship, and it started with Governor Herbert and is extended to Governor Cox. And I think I could be safe in saying our relationship with the state of Utah and the governor's office is as good as any with all the tribes. And because we're a little different, we assimilated into the culture. I don't know if that makes it easier for us because we don't have some of the problems the reservation natives have, but there's a difference between having a great relationship and being friendly to one another. But when it comes right down to it, we're renegotiating our hunting and fishing rights with the state of Utah. And what that means at the end of the day is we're going to give up something, and they may perceive that they're giving up something by allowing us to do what treaty rights have given us. So I'd really love to see the state of Utah live up to the sovereignty the way we want it done, and working with them to make sure that it's fine. The other thing I would change is I'm really a big proponent of Native American curriculum, especially in K through 12. I'm starting a nonprofit soon to really focus on Native American curriculum, the correct curriculum, especially in our elementary schools. I think when those true histories are told and the histories and perspectives of those Native people that have never been heard before, I think we can begin to change the culture. And the third thing is, and this has to do with Dustin, I mean, if I hear the governor say all the time, we have a great commitment to our Native people, but his position isn't a cabinet level position. And so is it lip service, or do you really, really have a deep understanding and care for Native American people? Because I think if you did, we would make the Division of Indian Affairs part of his cabinet and give us a seat at the table, so to speak, a table that we've never really had a seat at.
Great. So this next question says, Dustin brings an incredible and helpful view of the Native American tribes in Utah, some of who have land and some of who do not. What would it take to get some land given to those without land for a reservation, since 75% or more of the land in Utah belongs to Uncle Sam?
Well, it would take looking at what their traditional land was, right, and really looking at the history, looking at the people, and looking at what the laws really recognize their traditional land was to begin with. So we have an area about where we want to be, right? Another thing that we have to consider too is if they're, for San Juan Southern Paiute's position, they got engulfed by the Navajo Nation. So there would have to be an agreement with the Navajo Nation and the San Juan Southern Paiute. And there may be an agreement there that's valid, and they're waiting for something to happen next. They're waiting for next steps to occur. But as Mr. Parry stated, Congress has plenary authority over tribes, and Congress has authority over all federal land. That's one of their enumerated powers here. And so Congress it would take a congressional act to open up some land and an agreement between the tribes seeking land, tribes that may be currently occupying that land, and probably a fight from the state that doesn't want to see any more land go into trust status, which would take away tax opportunities on that.
Great, thank you. So this next question is actually one for me that says, when is the law school and/or the Utah Bar going to form a section for lawyers who would like to help Native Americans become real Americans? Put me down as the first member. So I'm not exactly sure what the question means by real Americans. So we Indians did get citizenship in the United States in 1924. We were the last group to get citizenship, but we have had it now for almost 100 years. But in terms of, I'm happy to update you of what's going on at the law school, and then also to let you know that the Utah Bar Association does have an Indian law section. So I definitely encourage you to participate in that section. They're always doing great work. At the law school, we've made progress, but there's work still to be done. So for example, the land acknowledgement statement that you heard me state earlier, I worked as co-chair on that committee to develop that statement. We have had success in hiring. We currently have 3 federally enrolled tribal members who are faculty at the law school, which is one of the largest percentage of Indian faculty members in the country. There are only a handful of law schools who have more than that. So that's helpful to have those perspectives in the law school. We've also been working on recruiting. So for example, we currently it is sitting with the Navajo Nation. We have a memorandum of understanding, which would lead to an increased number of Navajo citizens within the College of Law. And then if that agreement is successful, we would love the opportunity to reach out to the other tribes in the states to see if we might be able to form a similar MOU. We've had outreach from the Ute tribe to work on the development of a possible externship or clinical opportunity specific with that tribe. And again, would welcome the opportunity to partner with other tribes as well. And a big shout out to Carrie James, who's a citizen of the Navajo Nation, who has done a great job of forming a Native American Law Students Association chapter. And I'm very pleased to report they recently had their first meeting and the room was full. So it was great to see so many students who are interested in Indian law. And we're going to have at least one team compete in the National Native American Law Students Association Moot Court competition, potentially 2 teams. So good things are happening. We still have work to do, but we're very excited about the work that's been done and the great work that our students have been doing as well in this space. So next we have a question for Darren that says, are you aware there's a solicitor's opinion from the Regional Solicitor's Office in Seattle that recognizes the Northwestern Shoshone treaty right to hunt and fish?
Yes, I am aware of that. In fact, Dustin and I and Larry Echohawk made a trip to Boise recently and met with the Attorney General. And that solicitor's opinion was brought up in that meeting. And so we've always known it to be the case, but you know what the problem is really? The Shoshone Bannock are the stumbling block to all of this. They're the ones who are advocating for us not to have treaty rights, that we're not party to the treaty because we didn't move to a reservation, which was part of the treaty. And so it's not so much the state of Idaho that's been the stumbling block in this case. And going forward, it's another Native American group. And so I wish we would have followed Tecumseh's advice all those years ago and worked together and to make it a better place. But we are aware of that opinion, and we'll probably end up using it down the road and relying on that heavily. And we've made reference to that quite often. But thank you for bringing that up again.
Great, thank you. So next, there's a question, is there any thought or effort for the tribes to enact uniform laws and rules, similar to state uniform statutes and procedural rules, to achieve consistency from tribal jurisdiction to jurisdiction?
Well, I think there are some instances where we can see that kind of happening. But beforehand, you really do need to step back and look at tribes as, especially the tribes here in Utah, as 8 separate individual tribes, 8 separate geographical locations that offer some geographical amenities. Some have a lot of water, some have none, some have trees, some have none, some are close to towns, some are far from towns. Navajo Nation, as big as 3 eastern states put together, has 19 clinics and 6 grocery stores, right? Can you imagine, and so the needs of all these tribes are very different. So that's really hard something to do and have something to agree upon. And like I said, just because they're tribes does not mean that they get along, right? And Mr. Parry just said that. And both Shoshone people, maybe not related, but, language wise and culturally, a lot of similarities, but 2 separate governments really working to defend and the rights of their people. Mr. Parry said, this is a federal treaty right. It's a right. They don't even need a cooperative agreement with the state to hunt on their traditional lands and unoccupied federal lands. That's a federal right, as opposed to state privilege to hunt and fish, right? But trying to do these things and work together is and finding those ways that how to find the benefits by working together for each group, it can be difficult. One thing that we're doing in the state of Utah, as we're tribes coming together and working together, is developing an Indian Child Welfare Act on the state level. The Indian Child Welfare Act is a federal law that comes under attack every couple of years, every year probably that I know of. But protecting those rights and protecting Indian children and preserving tribal culture and function on the state level. So having a state statute that mirrors the federal ICWA laws is something that could help tribes to work together here within the state. And that's, I would, if you're interested, look at it. It's going to be coming out in the state legislation, the state legislative session in February, and tribes are currently working on that. And so it's exciting because there are state legislators that believe that it's important and are willing to sponsor it and help push that through.
Wonderful. So next we have lots of great questions, by the way. Thank you so much. Next question is, how do we get treaty rights to really actually have the significant, even supreme status as stated in the Constitution?
Good question. I don't know. How do you make people do the right thing for the right reasons? I mean, it's become such a political force. And even in my lifetime, I mean, generally speaking, courts that are more conservative generally don't have Native Americans' interests at heart. And thank goodness for Judge Gorsuch on the Supreme Court bench, because otherwise we might be looking at things completely out of a different lens even today with some of the recent rulings that have come out. I'm not sure how we do it and how we get there, but I guess we do it by, when you give a group of people a voice and a seat at the table, that voice has the opportunity to expand, and you can get people on your side, and you can get people to advocate for you. And we just need a seat at the table. And I really think it's time. I think it's Native Americans' time. And as I travel around the country and talk about Native American issues, I find the people that really want to listen and help to be much greater than it was even 10 years ago. I think we're at a place now that we have a good opportunity to make real headway with elected officials and leaders, and some of that will start, by giving us by getting into the classroom and sharing our perspective for once. So
I think you're absolutely right. It's getting people to do the right things for the right reasons. It's education. Also, I mean, K through 12 education. As a student, as a college student, and I'm not, I look older than I am, but I used to do programs at a class at Brigham Young University where I had to visit schools and talk to them about Native America. And I had 10 schools assigned to me that semester. 8 of the 10 schools introduced me like this. This is Dustin Johnson. He's not a real Indian, but he's going to talk to you about Native America. And I was like, did somebody write that down in my bio? Because this cannot be a coincidence, right? But students didn't even know there are Native people still there. I had about 6 of those teachers. I asked them, hey, what did I do growing up? And, we'd name off all these things. And then I would say, did I go to school? And not even the teachers would raise their hand on whether I went to school or not. And I'm saying, you requested me from BYU, right? I'm a college student. I got here. But we need that education out there. We need to see tribes as they are. We need to see tribes in the present. And even for state leaders and federal leaders, a lot of them do not see tribes in the present. I think part of the education is making sure we teach tribal government in civics classes. You can teach tribal government right along with city, state, and federal government in civics through the entire year, rather than dedicating one day a month or 1 month a year to make this happen. Seeing them as functioning governments with a voice, I think that would do an awful lot. But Wilma Mankiller said, public perception creates public policy. How you see people determines how you treat them. And on a government-to-government basis, how you see people will determine what laws are created that affect those people. If you really want to know how your government or your community feels about you, look at the laws that affect you. And if our government leaders can see tribal governments as sovereigns, true sovereigns, and recognize treaties as the Constitution wants them to recognize them, as the supreme law of the land, rather than a backdrop or that is relative to change like any other legislative law, it's not going to happen for a while. And so we need people to change. We need people to do, just as Mr. Parry said, do the right thing for the right reasons.
Yeah, wonderful. I absolutely agree. And I'll just add in, building on what Mr. Parry said about now is the time. We have seen some recent success. So you may have seen in the news, Washington got its first Native federal judge. Of course, we have a Native federal judge here in Utah, Judge Romero, who's a magistrate judge. And we've seen, of course, we've got Deb Haaland, who is our Secretary of the Interior, and several other high-ranking officials. We have our first Native who was selected as a law clerk for the U.S. Supreme Court. Justice Gorsuch finally took a Native student as a clerk, which you may wonder, why is that impactful? Clerks oftentimes are doing the research and helping to write the briefs, so they definitely have impact there. So there have been some improvements, but there's a long way to go and a lot to be done. And so I definitely agree now is the time, and it'll be exciting to see what happens. So with that, I think we have time for one last question. And the last question is for Dustin. Several people would like to know, what Utah state representative can we contact to help support the state's version of the Indian Child Welfare Act?
So if you would like to get involved and help, there are two representatives that you can work with. Representative Angela Romero. She'll be a sponsor. A co-sponsor on the Senate side would be Jani Iwamoto. Both of these individuals do a lot for cultural groups and cultural communities throughout Utah, and really spearhead the legislative drive to help those communities. So Angela Romero and Jani Iwamoto.
Fantastic. Thank you so much. And that's actually a wonderful transition, because I wanted to let everybody know that we have a part 2 to this webinar series, which is going to be same time on October 22nd. And that focus is going to be on the legal realities of Native Americans in Utah and how attorneys can help. So building on this question of how you can help with the Indian Child Welfare Act here in Utah, there's going to be a lot of discussion with what you can do during that October 22nd panel. So I encourage you, if you enjoyed this panel, to join us for that second panel. I think it'll be a wonderful conversation. In fact, I know it'll be a wonderful conversation. And I also just want to say, Che Magwitch, again, thank you very much to our amazing panelists, Darren, Parry, and Dustin Johnson. As I mentioned earlier, these are two gentlemen that I have tremendous respect for, who are doing great work both on the national scene and here in Utah. So thank you so much to you. Thank you for your time, and thank you to all of you who will be able to join us. And we look forward to hopefully seeing you again on October 22nd. Thanks so much.